Those of you that don't know me, my name is George Owens. I'm known on the forums as Poke and Dagger. I'm the Region 7 coordinator, at least until they find somebody else. Okay, today we're going to be talking about gun laws in Alabama. If you've been on the forums, if you've been on the Facebook, you see a lot of diverse opinions about what Alabama gun laws mean. I'm hoping that we're going to clear up some of the misconceptions, some of the ambiguity that is in the statutes, so that when you leave here today, you're going to have a more fuller and a clearer understanding of not only what the laws are in this state, but also what your rights are as a citizen of this state. We all know the United States Constitution. Well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Means that you have a right to a gun. But what came first before your right to bear arms? Well-regulated militia being necessary to the security of a free state. That is the federal's purpose for you having a gun. In time of national emergency, they want to be able to stand up on a podium and say, you, get your gun, come on. The last time that a militia was used by the United States government was during World War II. There were coast watchers. None of them ever saw combat, but the home guard, just like in England, was there. If the war had gone the wrong way, and England had fell, and France had fell, and Europe had fell, and Russia had fell, does anyone here have any doubt that Hitler's next target would have been the United States? Does anyone here doubt that with our resources, with our vast wealth, with our lands, with our industrial capacity, does anybody here have any doubt that sooner or later, on the horizon of the Atlantic and on the horizon of the Pacific, that we would have been looking at ships flying the swastika and flying the rising sun? If you have any doubt, erase it. I guarantee you that was part of the plan. They were saving us for last. What most people don't know is Alabama Constitution, Article 1, Section 26. I don't know how familiar you are with the history of the United States Constitution, but we had a Constitution before we had a Bill of Rights. They wrote the Constitution, what the President does, what the Congress does, what the Senate does. They wrote all of that, and then they sat back and said, hey, wait a minute, something's missing. We didn't fight this war to create another monarchy. We didn't fight this war to create a new, abusive, omnipresent government. We fought this revolution because of the abuses that we suffered at the hands of the British. Therefore, we need to forever enshrine the rights of citizens. And so they wrote them. In Alabama, we weren't even a state. We weren't even a territory when the first Constitution was written. So when it came time for Alabama to become a state, what is the first thing that our founding fathers did? The first thing that they did was they wrote Article 1, which is Alabama's Constitutional Bill of Rights. One of those rights, which has never changed, is that every citizen has a right to bear arms in defense of himself or the state. Now, does anybody see the difference between the federal right and the state right? Who comes second in the state right? The state. The state. The primary purpose is to allow a citizen to bear arms in defense of himself. The state is an afterthought. In the Fed, it's the forethought, because the Fed is always concerned about insurrection. They're always concerned about invasion. They're worried about wars and conflicts and foreign relations and international trade. And so they wrote theirs to facilitate the federal purpose. We wrote ours to facilitate the purpose of the citizen. The laws that relate to guns in the state of Alabama are found in Title 13A, which is the Criminal Code, Chapter 11, Article 3, and there's two divisions. We're going to be focusing today on Division 1. We all know 13A 1150. This is the reason why we have pistol permits, except as otherwise provided in this code. Now, between Division 1 and Title 13A is the entire criminal code of the state of Alabama. Now, why did they use this term, except as otherwise provided in this code? Does the self-defense statute, use of force in defense of yourself, does it reside in Article 3, Division 1? No, it resides in another chapter, a whole other chapter far removed from this one. So that's the reason why it said by the code. A person who carries concealed about his person a Bowie knife or a knife or instrument of like kind of description, or a pistol or a firearm of any other kind. That means anything that shoots that you can carry concealed. And what you're fixing to find out is this title, as far as it relates to carrying of guns, focuses solely on the elements of concealment. This one we hang our hat on. State versus Reed, 1840, Alabama Supreme Court. The state legislature passed a law that said you cannot carry a concealed weapon in the state of Alabama, and if you do, we're going to fine you. Does anybody know what Mr. Reed did for a living?
Sheriff.
Sheriff of what? Montgomery County, Alabama. Does anybody know the story behind Sheriff Reed and how he ended up in the Alabama Supreme Court?
Somebody after him, he put in jail.
There we go. There was a gentleman in Montgomery County, Alabama that had a bone to pick with Sheriff Reed. He didn't like him, and he was going around the countryside saying that he was going to kill Sheriff Reed. Sheriff Reed had a friend. As I recall, as I read it, the friend was a doctor. The doctor, upon learning of the threat on Mr. Reed's life, was so concerned, based on the reputation of the individual that was threatening, that he gave Sheriff Reed a pocket pistol, which Sheriff Reed promptly began carrying in his pocket. Now, what we don't know, or I haven't been able to find out yet, is what led to the arrest of Sheriff Reed. But suffice it to say, he was, somehow or another, it became known to some authority, probably the Montgomery Police Department, that Sheriff Reed was carrying a concealed weapon. He was promptly arrested, tried, and convicted. His case made it all the way to the Alabama Supreme Court. The Alabama Supreme Court said, you do have a right in the state of Alabama to carry a gun, but you must carry it openly. You can't carry a concealed weapon because the state legislature has prohibited carrying a concealed weapon. So the most appropriate expression of the Article 1, Section 26 right is for you to open carry. From 1840 until like about 1948, 49, sometime in that time frame, Alabama did not have a state statute that authorized anyone to issue a pistol permit. Let me tell you how they got around that. If the sheriff knew you and the sheriff liked you, you got a set of creds. You got a sheriff's deputy's badge and a sheriff's deputy's ID card. You were duly appointed as a special deputy. This happened for many, many years. I first went into law enforcement roughly in around 1980. At that time, that was still going on. If you were a campaign contributor or a golfing buddy or someone in the community and you went to the sheriff, he would give you a badge and an ID card. That was your pistol permit, even though Alabama at that time already had a pistol permit statute. That is now no longer the case, because to be a reserve auxiliary sheriff's deputy, you must attend minimum standards training. And it is a lengthy course, and it takes time, and it takes money, and sheriffs usually don't spend money to train their good buddy. You know, no matter how many times they go fishing or whatever. So now, your only resort if you want to carry a concealed weapon is you've got to have a permit. This court case has never been overturned. Can anybody tell me a recent court case in which this case was quoted? Heller versus D.C. The United States Supreme Court, this case is mentioned. This one is a bugaboo. This is the most misunderstood, misenforced, totally obnoxious statute in the entire code. Except as otherwise provided in this article, no person shall carry a pistol about his person on a premises not his own or under his control. There's no ambiguity in that. But the statute starts with except as otherwise provided in this article, which means that an officer that encounters an individual who is in possession of a firearm has to make a very complex examination of the situation that he's confronted with before he can determine whether or not the individual is violating 52. He has to look at the entire article. He's got to look at 50, 51, 53, 54, 55, 59, 73, and 75 before he can even reasonably conclude that a person has violated this statute. 13A1173 is the pistol permit statute. It says no person shall carry a weapon in a vehicle, concealed, or on or about their person without a license thereof. This is the case. You don't need to go any further to understand the relationship between 50, 52, and 73 than this case right here. CDJ versus State. This is a 1997 case that found its way to the Alabama Court of Criminal Appeals. CDJ was a juvenile, meaning he was under 18 years of age at the time of his arrest. Aside from reading the minutia of the opinion, what it basically says is failure of the state to prove that a juvenile did not have a valid pistol permit resulted in insufficient evidence to adjudicate the defendant as delinquent. If you're an officer of the law and you arrest a juvenile and he's on the premises of another and he is in possession of a weapon, there's two ways for you to present a sufficient case. One, you have to prove that the person was under 18 years of age, which means that they cannot possibly be issued a pistol permit. Or number two, you have to produce the sheriff or some document from the sheriff that says he didn't issue that individual a pistol permit. Then you get the adjudication of juvenile delinquent. But it gets even more interesting when you remove the juvenile aspect and you do it with an adult. On the website, if you've been to the forum page and you have looked at the case in Andalusia. This was a case that was brought in municipal court. The defendant made a motion to dismiss his case, and the judge granted the motion. The defendant was charged with carrying a pistol openly in a Walmart. He was not carrying concealed. He had a valid permit issued by the sheriff of the county. The judge ruled that because he had a permit, he could not be arrested for 52. We're going to get to why in just a second. No person shall carry a pistol in any vehicle or concealed on or about his person except on his own land, in his own abode or fixed place of business without a license thereof. Now, if you read that statute, where can you carry a gun without a permit?
Your own property.
Your own property and your own abode, your own business. But can't carry it in a vehicle. Concealed on your person, and then it says, or about his person. What is the legal definition of or about your person? We have a court case on that. Not too many people know about it. Not too many people have read it. It's buried. About the person must mean it is so connected to with the person that the locomotion of the accused will carry the deadly weapon with him. This is the plain import of the words in common parlance. This case is not on our website. It should be. This is Gaines versus McGraw, 1971. Also in that opinion it says, while it is not necessary to a conviction that the pistol was carried on the person, yet it must have been so connected therewith that the locomotion of the body carried it with it, the weapon, as concealed. So, I'm open carrying today. Is this weapon attached to me? If I go into locomotion, is it going with me? Am I in a vehicle? No. Am I carrying a concealed weapon? No. Therefore, open carry is on or about the person.
Can I ask a question?
Yes.
Can you have a gun in a boat?
No. Not without a permit.
Without, like, a pistol?
The Alabama Marine Police will tell you this is a question, and I put it to the Alabama Marine Police. I've got a good friend that works for them. Under Alabama law, a boat is considered a vehicle. I asked, well, I've got a sea ray, I've got a bedroom in it, I got a kitchen in it, I got a sofa in it. That's my house on the water. Don't matter. No different than a mobile home, no different than a trailer hooked up on a fifth wheel. If it's movable, the laws change regarding what you're required to do. So if you are in a boat, whether you're open carrying or concealed carrying, you need to have your permit with you.
You carry permit.
You carry a permit.
But you can take, like, a .22 to shoot the cottonmouths when you're fishing.
Sure. As long as you got a permit.
That's only for a handgun, though, right?
It's only for a handgun.
And
You can have a rifle or a shotgun. You can take your little favorite 22.
So you can take a .22 rifle in a boat.
Take a 22 rifle in a boat.
And
You
when
can
you're
take
fishing
12
and you see all
gauge.
those cottonmouths, then you can shoot them, and you do not get a ticket or get arrested.
Now, that answer. You just threw me a curveball and you didn't even know it.
I need an exception to that.
There is an exception exception to that. There is a game and fish regulation which says you may not take game within a certain distance of a fresh drinking water supply.
States like that.
What does that mean?
That means that if you're in your boat and you're tooling down the river and you see Bambi on the bank, don't shoot Bambi.
No, I'm talking snakes. On the Warrior River in Utah, snakes.
You know what? I'm going to plead ignorance to your question. I can promise you, because of my natural instincts towards snakes, you wouldn't, if I was carrying a badge and a gun and I seen you shoot a snake, you're not going to get a problem out of me.
And when I've got a minute in the water and over there is a big old coiled up cottonmouth.
I'd attack you myself.
I can give you a little bit of information on this, and I know it's not complete either. But first of all, if you're from Tuscaloosa, like Lake Tuscaloosa, that was built by the city. It's considered a public park. They don't allow alcohol out there or whatever, so the city officer catches you out there. I'm sure no firearms are going to be allowed in a public park. As for the Warrior River, Utah, where their core impoundments, they do a lot of duck hunting on these things. They don't allow firearms at any time unless you got a hunt permit, and the guns have to be with ammunition separated in a gun case, except during the actual process of hunting. So if your boat is underway, so if you run into a Corps of Engineers enforcement agent, which I've never seen except at a boat landing, but they do out there. So you run into all that stuff.
Yeah.
So after state law, we're good to go, but you run into all these other things, and how the federal government, I guess by us accepting tax dollars to build the dams, they can vote a agency that can regulate what occurs on public water is beyond me. But
Yeah, I can also tell you another thing that'll get you in trouble. Down, as you're going down the 10-ton waterway, you're going to encounter a number of chemical plants. You're going to encounter a number of power production facilities. When you are within a certain distance of a power production facility or a chemical plant that has hazardous materials, you may be entering into a area that has been designated as a security area, that is part of the curtilage of the plant itself, and there may be federal or state statutes that prohibit weapons in those areas. You know, so if you're like down in the Gulf of Mexico and wheel up to an oil production platform, you might want to keep your weapons out of sight, because they got real tight on restricted access to the waters immediately surrounding those kind of facilities in light of 9/11.
Yeah, we don't.
Here's another good case, KJ versus State. This is also 97. In this case, the court found a conflict and identified the conflict between 50, 52, and 73. You know, if you read 50 and you read 52 and you take it on face value without considering the other statutes, the problem that you're going to encounter is, if you read 52 and 50 in isolation, there's pretty damn well not any place outside your own home that you can carry a weapon. Here's the exception, 473. But 73 doesn't prohibit carrying an unconcealed weapon. Does 73 apply to 52 if you're open carrying? My opinion, and this is my opinion alone, some of you may choose to adopt it. I'll send you a cookie. But if you do, understand this. When a sheriff issues you a pistol permit, that pistol permit allows you to do three things. It allows you to carry a gun in a vehicle. It allows you to carry a gun concealed on your person. It allows you to carry a gun on or about your person. Well, the term "or" is an option. It's not an inclusive term, it's an exclusive term. All right. I like his hat, I like his hat. I especially like his hat because I used to be in the Air Force. So he's good to go. Who else? I'm not really good with the bean. But if I had a choice of wearing this hat, or this hat, or this hat, or that hat, can I wear all 4 hats at the same time?
Sure.
I'd look like a jackass is what I look. Let's say for the sake of argument, I only got one head, and a small one, and the rest would fall off. I could wear that one, I could wear this one, or I could wear that one, or I could wear that one. It's an or. Can't do both. If I say you can drive the red Ford, the pink Mustang, or the white Cadillac, you can't drive all 3 at the same time. Physically impossible. So the term or in this statute is an exclusionary term. So you've got carry in a vehicle, one method, or concealed on your person, or the third option, on or about your person. We've already read the definition for what about the person means. It's connected to you. If you have a gun in a briefcase, are you carrying it concealed, or are you carrying it or about your person? You may be a little bit of both, but I got a case in here that says that if you got a gun in a briefcase in the back seat of the vehicle, you're not violating the 50. Let me read this one to you. Ladd versus State. A weapon may be considered concealed when in a handbasket. Smith versus State. The fact that a weapon is not seen by one person but may be seen by others does not amount to concealment. Unless a weapon can be seen by an ordinary casual observer, it is concealed within the meaning of the section. That's Driggers versus State. Proof that a defendant had in his possession a weapon is not proof of carrying concealed weapons, but is only preliminary evidence which will warrant a conviction under this section. In other words, you've got to prove something else besides possession of the weapon. Here we go. Literal versus State. 1997. Man, I'll tell you what, they were popping people right and left in 97. Defendant did not carry a weapon concealed about his person by having pistol in briefcase and backseat of vehicle which he was driving. Now, if I was outside the vehicle and I was carrying a briefcase in my hand, yeah. So we have to remember what about the person means. It means that it's connected to you in such a fashion that if you go into motion, the gun's going to go with you.
So what is it considered if it's in the back seat of your car in a briefcase? What is that term?
It's not considered concealed about your person. You don't have immediate access to it.
It's still a violation of 73 if you ain't got a license.
Still a violation
So
of
it's a concealed
73
weapon in your
if you don't have a license.
I got 2 questions real quick. Okay, the first one, I got stopped by county. I open carry.
Right.
I had it on my side.
Right?
He told me when I step into a vehicle that it must come off my side in the glove box.
No. If you get into a vehicle, whether you have it on your side, whether it's in the back pocket in the door, sitting on the passenger seat, in the center console, the glove box, under the front seat, whatever, if it is in that interior passenger compartment, you need a permit. Okay? You can open carry in a car. I can go out there right now and get in my car and go. But while I am open carrying, I am also in a vehicle.
So you still need to have.
I got to have a permit.
What if it's in a trunk?
trunk is not part of the passenger compartment of the vehicle. You do not have immediate access to the weapon. If you don't have a permit and you're transporting a weapon in a vehicle that is a handgun,
What if you have a shotgun?
That was my next question.
there's no state statute that forbids long weapons in vehicles.
I've got a shotgun rifle rack on the back of my truck seat. I keep a shotgun and a rifle in the back of my truck.
Yep.
The same sheriff told me I could not carry in the back of my truck. It had to be like in the trunk or in a locked gun case.
I want to know the statute, because I've read this code back and forth, and I don't see any statute that prohibits a long gun in a vehicle.
So it is legal to carry in a rack in the back of your truck.
Yes.
Is that loaded or unloaded?
I mean, if there's no statute about carrying a rifle in a vehicle, what difference would it make if it was loaded or unloaded? Now, I will say this. When you carry a gun, we all recognize that this is a critically important decision that you're making. It is an awesome responsibility. You have on your hip the power to kill. You have on your hip the power to maim. You have on your hip the power to wound somebody that you don't intend to shoot. We are civilly and criminally liable for everything that comes out of the barrel of our gun. If I mean to shoot him and I hit Jason Tully between the eyes, but I was aiming at the man in front of him, I am probably going to be charged by the grand jury with criminally negligent homicide. Not to mention that Jason's wife is going to sue me for every penny I ever had, every penny I ever will have, and I will die poor and ashamed. If you're going to carry a gun in a truck or any kind of vehicle, and you're going to carry it loaded, make sure that your weapon is protected in such a fashion that, you know, if you hit that pothole, it's not going to jar your trigger and end up blowing a hole in your buddy's head or killing somebody in the car next to you at a red light. So, you know, I've got a Savage 308 rifle. I frequently carry it in my expedition, but it's got a pretty sensitive trigger. I've actually bounced it and had the trigger, the hammer fall. Fortunately, because of Savage's foresight, I've got a little gizmo on there that blocks the hammer until I pull the trigger, so the gun's not going to fire. So yeah, I would carry that kind of weapon. If you're going to carry a loaded rifle or a loaded shotgun, you might want to consider carrying one that has a pretty effective safety function, or simply carry it with the gun loaded but a round not chambered and the hammer down. This is an interesting case. This is from Baldwin County, Alabama. Morris versus State. This is in 1977. Mr. Morris was walking in the town square in the city of Bay Minette. He was observed by a Baldwin County Sheriff's deputy who immediately attempted to arrest him for carrying a weapon. Apparently, Mr. Morris knew a little bit more about the law than the Sheriff's deputy did, because Mr. Morris resisted arrest. He was, in fact, indicted by the grand jury of Baldwin County, charged not with carrying a weapon, but he was charged with resisting a lawful arrest. Gets up to the Supreme Court, they said, State failed to prove the arrest was lawful. In fact, it was not lawful, because he was not carrying a concealed weapon. Now, the one thing that I haven't figured out, haven't been able to find out, was whether or not Mr. Morris had a permit to carry concealed. It is to be observed that this law prohibits carrying a pistol concealed or not in any vehicle, or concealed on or about his person, except without license thereof. It does not prohibit a unconcealed pistol. This is the most recent Attorney General's opinion. These are the others, and these are up on the website in the forum page. There was a city that wrote to the Attorney General and they said, hey, look here, we got these dog catchers. They got to go out, and whenever they go out, they're being attacked by dogs. Sometimes they're being attacked by dog owners. Can our dog catchers carry pistols without, like a police officer? Well, I don't know, last time I saw a dog catcher, he was wearing blue pants, black shoes, a blue shirt, had a little badge on it, said Animal Control Officer. You add a gun belt and a gun to that, you might be under the impression that individual was some kind of a sworn law enforcement officer. But animal control officers are not sworn officers. The AG took a look at the statutes, he took a look at the case laws, and that's what he came up with. You can carry a sidearm as long as you do what? Same thing as everybody else.
But that appears only to apply to non-commissioned animal control officers.
No, it doesn't. Officers may carry a sidearm if such officers follow the same procedures as any other subject. I'm a dog catcher, man. I'm just like
I've
you.
always wondered.
Okay. Well, now you know that if you ever become a dog catcher in your next life or in the you can carry a gun in the state of Alabama unless they screw up and change the law.
But when you eat them, would you eat them, or would that be against the game rule?
Do what now?
Against the game rule if you eat them after you shoot.
You know, I was kind of hesitant to tell her that, I've been known to eat a snake or two. So.
Oh, gosh. They just need to die.
Here is really another interesting statute. And this is one that you almost never hear anybody talk about. Indictment for carrying weapons unlawfully. Proof. I'm sure that many of you have read the statutes, same ones that I've read. Does anybody, can you tell me what the statute code section is for carrying a weapon unlawfully? Because I've looked from one end of Title 13 to the other, I don't see it. I see a lot of statutes dealing with guns. I see a lot of statutes dealing with a lot of crimes, but I have never seen a crime called carrying weapons unlawfully. Well, I scratched my head and I said, George, what the hell are they talking about? I'll tell you what they're talking about. They're talking about the entire code section. In an indictment for carrying a weapon unlawfully, it is sufficient to charge that the defendant carried concealed about his person a pistol or other description of firearm. Now, where does that come from? The term other description of firearm. Well, one of the statutes that we're not dealing with directly today, and I want to make sure that I give you the right one. I've got the code section right here. Is a statute that deals with a shotgun rifle or a shotgun cane. There's brass knuckles and sling. Here we go. 13A 1154. Can't carry a shotgun rifle or a shotgun cane. Right after that is 55. So we've got pistol or another description of firearm on the premises not his own. I screwed up when I was a kid. I slept through English class. When you have a comma What does, in a run-on sentence, what does the comma substitute for? By the rules of English language? The word and. Now, the defendant carried concealed about his person a pistol and on a premises not his own. That's the exclusion to 52 for open carry without a permit. In order for a DA to be able to prove an offense, this establishes by statute the burden of proof that he must meet. Now, you can torture this any way that you want to. We got an or here. We got an or here. We got an or here. We got another or here. But we don't have an or right there. So if they did, you know, they bothered to stick all these freaking oars in the water, but then did not put one before on a premises not your own. So in the absence of an or in front of this phrase, this comma in this sentence substitutes for the word and. It only says that the defendant carried concealed about his person a pistol or other description of firearm. The weapon's got to be concealed. It doesn't matter if it's a bazooka. If you carry it openly, you can't be convicted under 50 or 52. Why would they ban, now, why would you want to conceal a shotgun cane or a shotgun rifle? Well, you wouldn't. It's already concealed. It doesn't look like a gun. The Alabama legislature has always had a prejudice against concealed weapons. They don't like concealed weapons. Why is that? Because if a criminal is going to commit a crime, he is going to do so with a weapon that he has concealed. He is going to approach you by stealth. He is going to approach you quickly. And as soon as he thinks he's close enough to strike, give me your money. So that's how it's going to happen. That's how it's always happened. From the time of Sheriff Reed all the way to today, people carry concealed weapons, commit crimes. They don't carry them openly. Why? Because it draws the attention of law enforcement. When I was a cop, if I was driving in certain neighborhoods and I saw somebody carrying an AK-47, he's got my undivided attention. Now, I may not just run right up to him and say, hey, bud, what's going on? I'm going to lay back. I'm going to watch him. Guy might be going to the range. Good people do live in bad neighborhoods. I don't know if y'all realize that or not, but good people do or are sometimes forced to live in bad areas of town. Doesn't make them a criminal. And bad people live in good neighborhoods. Boy, I tell you what, I've seen some folks that had money, but they were pure trash. So think about this. Think about the absence of the operative term or in this sentence. Think about carry on or about your person but not concealed or in a vehicle. That pretty much shoots my game for today, for right now. Hoss is fixing to start talking to you. I kind of helped Hoss a little bit with his presentation because he needs for lack of a better term, a crash test done. So I will be Hoss's crash test dummy for the next presentation. I think we'll probably take us about a 5-minute break. And then we will come back and we will get started with Hoss.